Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. We're going to continue on with the very last witness from the closed sealed hearing, a name that you may remember if you've been following the case from when it was in Latah County, Dr. Leah Larkin. Her direct examination commences at page 141, line 23. "Good afternoon," Ms. Taylor states, to which Dr. Larkin states, "Good afternoon." Question: "Will you say your whole name?" And we go on to page 142. Answer: "Yes, my name is Leah Larkin," and it's spelled, and she provides the spelling of her first and last name. Question: "What do you do for work?" Answer: "I'm a genetic genealogist." Question: "What kind of background and training do you have?" Answer: "I have an undergraduate degree in biology from Swarthmore College in Pennsylvania, and I have a PhD in biology, specifically in the field of botany from the University of Texas in Austin." Question: "How long have you worked in genetic genealogy?" Answer: "I started doing it as an amateur in, I believe, 2013, and I started taking professional clients in 2016. Question: "What does that mean you take on professional clients?" Answer: "Most of my clients are people like an adoptee or somebody with an unknown father who is trying to identify that particular relative. So I can use their direct-to-consumer genealogy DNA test, build family trees, and work to identify their biological family." Question: "So your work happens after the SMP is produced?" We're at the top of page 143. Answer: "Yes." Question: "Do I understand that right?" Answer: "Yes." Question: "Do you know what whole genome sequencing is?" Answer: "I do. I have not done it myself, but my training is biology. I understand what it is." Question: "Based on your work in genealogy, are you aware of what kinds of things are contained in the whole genome sequencing field?" Answer: "Right. As a few of the earlier witnesses have said, the genome is basically the blueprint. It's the instruction manual for your body. So first of all, it makes you human. But it also can determine your hair color, your physical traits, your eye color, and then there are a lot of genes that are going to be associated with other things, like whether you have a propensity for Alzheimer's or your height, your weight. Basically, all of these traits that make us unique for the most part are coded in our genes, our DNA, in one or more genes." Question: "Is there any aspect in your field where medical information can be known?" Answer: "Yes. So the DNA tests that are used for genetic genealogy are called microarrays. So when, and we go on to page 144, you spit into a tube and send it off to one of these companies, they're going to do what's called a microarray. A microarray test was designed for biomedical research. They weren't designed for genealogy. Genealogy was like an afterthought. These are tests that were created specifically to target physical traits, health traits, and it just happens to be useful for genealogy as well. So even if I do a test and don't look at those traits, they're still in the data file." Question: "When you get the work, do you have to make a choice as to what kind of database you're going to do your research in?" Answer: "Yes. So if I'm taking a client who is, for example, an adoptee, I will have them test at Ancestry and 23andMe. So those are two companies where you actually have to send in a spit sample to get into their databases. They don't take data files from other sources. The most cost-effective way to do this for an adoptee is to test at those two companies and then take one of the data files you get from, say, Ancestry, and upload it into the smaller databases. That way, you don't have to pay for a whole new test." Bottom of page 144 going into 145. "You don't have to wait to mail it off and have the lab run it and get the results back. You can normally get your results in a day or two after you do the upload. So for an adoptee, there aren't really restrictions on what databases you can use because they were all generally created for amateur genealogists." Question: We've talked a little bit today about databases that have restrictive use. Answer, yes. Now, once again, ladies and gentlemen, I want to point out that unlike in some other cases, situations where the judge will sequester witnesses, the witnesses do not get to come and sit in the gallery, sit in the courtroom until after they've already testified. Here, what happened is all of the witnesses, if they wanted to, sat in the room and they could listen to the witnesses who came before them before they testified. So this is what this is, I believe, addressing when Ms. Taylor says, question, we've talked a little bit today about databases that have restricted use. Answer, yes. Question, what does that mean? Answer, so forensic genetic genealogy, which is also sometimes called investigative genetic genealogy, and then there's the combined FIGG. Just because we can't decide, that is restricted to two main databases. There's family tree DNA, which we call FTDNA for short, and then there's GEDmatch. And those are the only two databases of any significant size that allow FIGG searching. Ancestry forbids it, 23andMe forbids it, MyHeritage forbids it. Question, does GEDmatch have two sides to it? Answer, yeah. Actually, both GEDmatch and Family Tree DNA have a specific upload process for forensic kits. We call these tests a kit. So if you're a normal, regular adoptee, you can upload through the main layperson portal. But if it's we're going on to 146 forensic kit, it's supposed to go through a special upload process. At GEDmatch, they call that GEDmatch Pro. Family Tree DNA does not have a special name for it, to my knowledge, but there is a special process you're supposed to go to, and those kits that are uploaded through the forensic portal are restricted in which other kits they can see. The idea is that if you don't want to participate in a forensic search, if you're a lay person and you don't want to participate, you can opt out. And so a kit that is uploaded through the forensic portal should not be able to see a lay person kit that is opted out. Question, do you know why these databases have these different, I guess, abilities or rules? Answer, yeah. So I'm sure we're all familiar with the Golden State Killer case. At least we've heard about it. That was the first big criminal case that was solved through this type of genetic genealogy. There had previously been one doe, unknown remains, that had been identified a few weeks earlier. But the Golden State unaliver case is the one that got all the media attention. On the one hand, there were people who were really excited about the prospects of capturing violent criminals using this method. At the flip side, there were a lot of genealogists who were, and we're going into 147, really concerned that they might be drawn into criminal investigations without their knowledge or consent. And so the community split. There were a lot of Facebook groups, a lot of genetic genealogy is just done through Facebook groups, and some of those Facebook groups just basically forbid it. You can't talk about this at all because it was causing too much conflict within the community. I went to a conference shortly after the Golden State, ladies and gentlemen, unaliver case was announced, and I was a speaker. And they pulled all the speakers inside and said, don't talk about it at all. You're not even allowed to mention it at all. This is how conscientious it was in the community. So the database is realizing that this was a problem. So Ancestry, 23andMe, and MyHeritage all very quickly changed their terms of service to say, no, you can't do this on our databases. GEDmatch and Family Tree DNA over the course of the past few years have kind of evolved into those systems in response to public outcry about privacy and consent, and also in response to some breaches and some missteps on the part of the companies themselves and on the part of some of the genetic genealogists. So they evolved these systems to allow the users to opt out if they don't. 147 going into 148 want to participate. So the public outcry, that was people that didn't want their profile searched by law enforcement. Answer, right. Prior to this, there had been occasional discussions in the genealogy community. People saying, oh, the cops are going to get our data. And other people were like, no, they only use CODIS, so they're not going to use our databases. And it turns out they were. The Golden State, ladies and gentlemen, I'm going to use the term unaliver, case was being investigated. I'm not sure exactly when it started. I think 2017. And he was arrested in April of 2018. So law enforcement or genealogists working on behalf of law enforcement were in fact using the databases without the knowledge or consent of the regular person, genealogists who were in the databases. Question. So was it 2018 when the terms of service used in people's privacy rights were recognized? Answer. So there's a whole series of changes to the terms of service, so I can't speak to precisely what dates and which databases and which changes. I recall that MyHeritage, which within a few weeks of the Golden State, we're at the bottom of page 148 going into 149, being arrested, changed their terms of service to explicitly say, not in our databases. Question, all right, let's talk about this case. Were you brought on to help us in this case? Answer, yes. I was brought on to help you interpret and understand that was done in terms of the genetic genealogy from this case. Question, what did you look at to do that? Well, answer, it's been a bit of a struggle getting all of this material I would like to look at. So I have seen basically photos of a giant kind of poster scroll of a family tree that I believe the feds built at ancestry.com. I've seen pictures of a whiteboard in which they sort of like hand wrote on this whiteboard a descendant tree. So basically looking at some ancestors and mapping out the descendant lines leading to certain DNA matches. I've seen communications between, in some cases, I can see who the recipients are. In some, I can't. But I've seen a lot of email communications about the case. Do you want me to go on? Question, no. In the course of your work to try to help us understand what happened here, did you learn that first Othram worked on the case and then the feds took it over? Bottom of page 149. Answer, yes. So Othram, I believe, they were contracted based on the invoice I've seen. They were contracted to do the lab work. So to actually generate an SMP profile, upload it to GEDmatch Pro and Family Tree DNA, presumably through the approved portals. And then I believe they were contracted to do the genetic genealogy. But they were told to stop work, I believe, on December 10th. And I've seen the preliminary report they wrote. All right, have you had a chance to look at what happened after December 10th? And this is a question from Ms. Taylor, ladies and gentlemen. Answer by Dr. Larkin. So after December 10th, there were some email communications between the one I think was most interesting to me, had the names redacted, and it contained screenshots. So to backtrack a little bit, the Othram report reported two main DNA matches. One of them shared 70.7 centimorgans of DNA. The court reporter, 70.7? The court reporter interjects when she has not heard the response or the question as she's done here. This is on line 18. The witness, 70.7, and then she spells CENTIMORGAN. And we just abbreviate it small c, capital M. The other one, Dr. Larkin continues on line 22 of 150, I think was 60. And Othram's report specifically said, those are low matches. Othram figured out how those two people were related to one another. I believe they were third, and we're at the bottom of page 150 going into 151. They were third cousins to one another, and based on how much DNA they shared with the crime scene profile, they thought that the individual who contributed the crime scene profile was descended from the second great-grandparent of those two matches, a man named Redacted and his wife Redacted, I believe were their names, and they were both born in the Redacted. By Ms. Taylor. When Othram quit work, were they following a family tree that could have led and come to Brian Kohberger? Answer, yes. Based on my initial review of what they did, the crime scene profile was most likely descended from redacted and redacted, or perhaps from one of their siblings. It's hard to tell which DNA because it's not at all third cousins share exactly the same amount of DNA. Some share more, some share less. It's just kind of a statistics game you play. Ladies and gentlemen, I just want to point out here, names are redacted because of an order that Judge Hippler entered. The state requested that certain information be redacted from this transcript. One was the name of a roommate and a witness, is what this individual was described as in the request for the redaction. The others had to do with the names that came up from the Othram analysis of this DNA of these potentially distant relatives. So that's why this is redacted here. We're going to go back. Line 9. When Ms. Taylor, when Othram quit, were they following a family tree that could have led and come to Brian Kohberger? Answer from Dr. Larkin. So based on my initial review of what they did, the crime scene profile was most likely descended from redacted and redacted, or perhaps from one of their siblings. It's hard to tell with DNA because it's not all third cousins share exactly the same amount of DNA. Some share more, some share less. It's just kind of a statistics game you play. That couple had redacted children. And so there conceivably could have been hundreds of descendants of this couple. I haven't seen the full tree. I've just seen that they had redacted children. Othram chose one of those children and had tracked down, I believe, grandchildren. Not great-grandchildren, ladies and gentlemen, grandchildren. Apologize. I believe grandchildren. And there were 4 brothers. They recommended testing one of those, bottom of page 151 to 152, brothers, to get more DNA, to get a closer handle on where their crime scene profile might fit into that family. Question. So when Othram stops there, and the feds take over, you told us you saw something from Ancestry.com. Would you have expected to see any other kind of file with that file? Line 8, Dr. Larkin answers Ms. Taylor's question by stating the following. Answer. So this was basically like a giant poster-sized printout of information from that family tree. A family tree, when you build one at Ancestry, it's stored in a specific kind of data format, or more precisely, you can download the file into a specific type of data format called a GEDCOM. Ladies and gentlemen, that's spelled GEDCOM, all in capital letters. Dr. Larkin continues, and it's a universal file format for genealogy trees. So you could take a GEDCOM file and you could open it up in standalone software on your laptop. You could upload it to a different genealogy company. I have a GEDCOM file for every single client case that I do, and I'm finished with an adoptee case. I basically give my client the GEDCOM file so that they have a record of all the work that I did. And I would have expected the feds to have that as well, but they did not turn that over. Question. You didn't see one of those? Answer. I did not see one of those, no. Bottom of page 152 going into 153. Question. Knowing that Othram finished their work on December 10th and then the feds took over, and we've heard that by December 19th, 9 days later, they'd made an identification. Is that significant to you? Answer from Dr. Larkin, yeah. Question from Ms. Taylor, why? Answer, because Othram's matches were, as in their own words in their report, those matches were low. They were recommending testing these 4 redacted brothers to get more information. If you went out and if you approached those men, and even if one of them said, yes, you can test my DNA, the testing itself would have taken some time. Getting a kit to a person, getting the spit, sending it to the lab, having it analyzed, and it wouldn't have led to the crime scene profile because it was the wrong family branch. So going from low match to an ID, or at least a tip, whatever they were calling it, within 9 days, That right there told me they had gone into a database they were not supposed to be in. Ladies and gentlemen, this is testimony from Dr. Leah Larkin, direct examination by Ann Taylor, counsel for Mr. Koberger. It continues. This is at line 21, page 153. Were those other ways that you were able to confirm your belief? Answer, yes. Question, what was that? Answer. So one of them, in one of those emails, we're going on to page 154, communications, I believe. This is the one that had both the sender and recipient redacted. There were screenshots from GEDmatch, and I believe it said, so there were screenshots. How do I put this? In GEDmatch. GEDmatch has a very open system. So if you are in GEDmatch and I am in GEDmatch, and let's just say we were cousins, I could go in and look at my kit and I could see you in my match list, but I could also go into your kit and see me in your match list. GEDmatch is just a super open database in that way. Any kit in the system that is public, you can see their matches. The one exception, however, is that if there are forensic kits in the database and I am a layperson and I'm looking at a layperson kit, I can't see the forensic kits. They are invisible to me. But there is an email communication that has a match list from the perspective of somebody who only used the initials S as in Sam, C as in Charlie, ladies and gentlemen. This is on line 18. I have no idea what this person's real name is. In the database, they are called SC. This screenshot is taken from the perspective of SC. And there is a match to the forensic profile from SC's perspective. That tells me the forensic profile was uploaded through the regular GEDmatch profile and not the GEDmatch Pro portal, because it should not have been visible to SC. We are learning about this mysterious SC individual here for the first time, ladies and gentlemen. It appears from Dr. Larkin's testimony. We're at the bottom of page 154 going into page 155. Line 25 says, or let's backtrack to 24, because it should not have been visible to SC. And the email says, quote, this one's ours. And the other thing is that GEDmatch will also tell you how many days a kit has been in their system. And for this kit, for the match to SC, it had been in the database for 1 day. But Othram had uploaded it. I'm not sure exactly when, but I would say 6 to 7 to 8 days prior. So it should not have said the kit was only 1 day old. Question, Ms. Taylor, line 9 to Dr. Leah Larkin. So based on that email and what you saw, it confirmed your belief that the feds used a not allowed answer. Right. So that was one. There were several lines of evidence. That was one of them that stood out to me early on, that they had uploaded through the layperson portal of GEDmatch so that they could see all the people that were opted out. There were a couple of other matches. One of them actually 250 centimorgans, which is something we get excited about in genealogy. And one of them was, I think, was closer to 70 that were not in the Othram report. If Othram had seen the one who shared 250 centimorgans, that would have been in their report. Like their genealogists are good, they know what they're doing. They would not have ignored a 250 centimorgan match. And based on those other two at the bottom of 155 going into 156 matches, at that point, I'm pretty sure that they had gone into the MyHeritage database. Question, while you were reviewing this information so you could learn and try to figure out what happened here, did you have any ability to call anybody from the feds and say, hey, what is going on? Answer, I don't know who did the genealogy work at the feds. Question, why is that? Answer, it's not in the information that we received. Question, is that the part that was redacted? Answer, I don't know if it was redacted or if we just never got it. So there was that one email that had been redacted, a redacted sender and a redacted recipient. Presumably, those were the people doing the genealogy work. But other than that, I have no idea who did the genealogy work at the feds. Ladies and gentlemen, we are now on line 19. Are there any other ways you know the feds went where they were not supposed to go? Question. Are there any other ways you know that the feds went where they were not supposed to go? Posed by Ms. Taylor to Dr. Leah Larkin. Answer. There was one piece of information in the discovery material I did review. I believe we asked them to turn over the match lists. And they were like, oh, we can't turn over the whole match list because it was 20,000 people. And that's actually bottom of 156 to 157. Right there was a big tip-off, because if they had only used GEDmatch Pro and only used Family Tree DNA, I think at most they could have gotten to maybe 10,000. So that right there tipped me off that they were in a database that they should not have been able to be in. Question. During the course of our work to try to understand what happened, did you assist us with reviewing documentation and teaching us what else should have been there that we needed to ask for? Answer, what specifically? Question, well, about the databases they went into and the match list. And answer, right. So we've talked about what you see in a match list. We've talked about the fact that you can download the match list at familytree.dna, that there's just a click button to download it, and you'll get a CSV file, which you can open in a word processor or you can open in a spreadsheet program. At GEDmatch, you can also get the whole match list. So you would have gotten that. I tend to do that for my clients, just so if I'm not online, I can still work through their materials and I can report that back to them. Question, and did you testify in a motion to compel hearing to try to get this information so that we could tell and confirm that you believed about the feds? And this is the bottom of page 157. Going into a non-allowed database, answer yes. Yes. Top of page 158. Ladies and gentlemen, as I stated at the beginning of this presentation, Dr. Larkin did provide testimony before Judge John Judge prior to change of venue. This was on the 4th and 5th motion to compel evidence, the IGG evidence that Judge Judge eventually ruled in 2023 that the state of Idaho should turn over in part. This is what this is relating to. Again, we're at the top of page 175, line 2, where she responds yes. Question from Ms. Taylor, and do you know if sometime after that we received confirmation that they did? Answer, we finally did get a letter from the feds in which, so we specifically asked to know which of the matches were in which of the databases, and they did not tell us that, but they did give us a list of the databases they had uploaded to, and it included Family Tree DNA, GEDmatch Pro. Those are the two databases they're allowed to use, but it also listed GEDmatch, not GEDmatch Pro, but GEDmatch. They're not allowed to go in the regular GEDmatch portal. And then finally, they admitted they uploaded to MyHeritage. Ms. Taylor, Your Honor, I am at D as in David 26, and I can pass this copy to the court. I would ask that it be shown to the witness first. So what she's doing here is she's asking the court for permission to show the witness a specific exhibit that's marked with this D defense labeled number 26. The court, what's the red number on it? Ms. Taylor, Your Honor, the red number is 999. The court, notice of in-camera submission? Ms. Taylor, yes. In-camera means not visible to the public. You'll recall that the exhibits that were sent to the court by both sides, many of them, if not most, were under seal. So this appears to be one of them, with the court referring to it as in camera, meaning for the court's eyes only, not to be put on the portal, not to be given to the clerk of court, not to be filed on the public docket. This is an in-camera inspection. The court, notice of in-camera submission? Ms. Taylor, yes. The court, all right, go ahead. Line 24 by Ms. Taylor. Dr. Larkin, will you thumb through at the bottom of 158 to the top of 159 that? It's toward the back page. Okay. Do you recognize that? Ms. Taylor asks. Dr. Larkin says yes. The second to the last page, it says, below are the genealogy services utilized by the feds. Line 7, and what does it tell you? Answer, it says Family Tree DNA, GEDmatch Pro, GEDmatch, and MyHeritage. Question, thank you. Ms. Taylor, would Your Honor like the copy they have there? The court, I think it's part of the record you submitted, so I have a copy. Ms. Taylor said, okay, thank you. Give me just 1 minute to check with my team. So earlier we had made the speculation that when Ms. Taylor had asked for it, Your Honor, if I may just have a moment, that she was going back and asking possibly the other members of the defense team that were at this hearing, what do you think? Or anything I missed? Is there something else I should ask of this witness? Because once the witness is off the stand, she's done. So we see here that Ms. Taylor is asking for the court's permission to check with her team specifically. This is the first time that she said this. Thank you. Give me just 1 minute to check with my team. This is on line 16 and 17. Line 18, we don't know how much time, again, she spent with her team. It just comes back as though there's no omission of any time at all. It comes back, question, answer, just what's on the record. That is what the court reporter will provide here. Line 18, I do have another question, says Ms. Taylor. The court, all right, go ahead. By Ms. Taylor, what is Prometheus? Promethease. And she responds, it is a third-party site, so it's not part of Ancestry, not part of MyHeritage. Actually, MyHeritage owns it. It's a site where you can take the S&P profile that you get from any of, at the bottom of 159 going into 160, the companies, and upload it to the site. And it will basically look for medically informative S&Ps in your profile, and it will do reports on them. I think it's like, I don't know, it's like a nominal fee, like $12 or something, and it will do a report of all the S&Ps that you have in your profile. Question, if I had my S&P, you could do that to find out? Answer, yes. I could do it on if somebody has done a genealogy test for $12. I can put it into the Prometheus system and get trait reports and health reports. Question, how extensive is that information you could get? Answer, it's pretty comprehensive. I mean, you will get reams and reams of reports. I should say that how do I put this? There are a lot of traits that are controlled by multiple genes. And so if a trait is controlled by multiple genes, I can't say for certain, yes, you're going to go Alzheimer's. No, you're not going to go Alzheimer's. It's more of a risk factor. But you can look at the multiple reports and see if they're, for example, giving you an increased risk of Alzheimer's or whatever other traits, bottom of 160 into 161, are in the system. If you have an increased risk of breast cancer, prostate cancer, or anything out there. Question, for $12, Ms. Taylor asks? Answer, yes. Question, thank you. That's all my questions. Hold on 1 minute. The prosecutor may have one for you. So it appears that from what we can tell here, although Ms. Taylor said I have no further questions, Ms. Larkin may have been getting ready to get off the stand, and she's telling her, hold on, the prosecutor may have a question for you. We look here at page 161, cross-examination. Yes, indeed, Mr. Nye did have a question, at least. Number 12, line 12. Good afternoon, Miss Dr. Larkin, by Mr. Nye. Answer, good afternoon. Question, so you testified that when people come to you wanting to do genealogy tests, you recommend Ancestry DNA and 23andMe. Is that correct? Answer, yes. Question, one of the reasons you recommend those two is because they have the most users in the database. Is that correct? Answer, yes. Question, and the reason why that's important is because when you're looking for Ancestry, really the best databases for you is the one that has your closest relatives in it, right? Bottom of page 161 going into the top of 162 where Dr. Larkin responds yes. Question, But you can't know that until you use the database. So you just use the one with the most users, asks Mr. Nye. Answer, there are two reasons to start with those companies. One is because they have the largest two databases, and then because you cannot upload into those databases, you have to test with them. You can test at Ancestry and then get into the MyHeritage and Family Tree and GEDmatch databases for trivial amounts of money. Whereas if you tested at Family Tree DNA first, the only way you're going to get into the Ancestry database is by doing another test. So I always recommend starting with the biggest, and then if you want more databases, you can upload into the smaller ones. Question, and one of the reasons you might want more databases is so that you can get more matches, right? Answer, yes. Question, you can gather more information that way. Answer, Question, and typically that's why people are coming and asking you about these databases, is because they want more information about their family, bottom of 162 into 163, correct? Answer by Dr. Larkin. People generally come to me because they need help interpreting the matches that they have. Line 5, Mr. Nye continues with his cross-examination of Dr. Leah Larkin by stating, I want to talk a little bit about the number of users in these databases. So we've been discussing the ones that were on that list. You read from the document, the feds indicated that they used in this case. Do you remember that list? On that list, do you know which of those databases has the fewest number of users? Line 12, Dr. Larkin responds to Mr. Nye's question as follows. I believe Family Tree DNA is currently about 1.8 million. It's not an exact number, but I think that's probably about where they are right now. GEDmatch, I think, a little over 2 million, and MyHeritage recently announced that they were at 9 million. Question by Mr. Nye, line 17. And when you say 1.8 million, you mean 1.8 million other people that have utilized their services and that you potentially could match with if you utilize that service. Answer, yes. Question, is that correct? I have a couple of questions for you on this Prometheus. You mentioned it costs money, $12, I believe you said. Bottom of page 163 going into 164. Answer by Dr. Larkin to Mr. Nye's cross-examination. I think it's $12. Question, why would someone utilize Prometheus instead of just reading their SMP profile themselves? Answer, the SMP profile is basically just a list. There's a location code, but it's going to be something like RS23744, and you're not going to know what RS. I don't even know what number. I just made that number up. You're not going to know what SMP is. You're not going to know what gene it's a part of. You're not going to know whether an A or a T is good or bad. Prometheus takes your data file and references published literature on that SMP's might impact in terms or traits, and then produce a report from that. Question. So, even you, for example, if you wanted to know medical information and you had your own SMP profile, you wouldn't just attempt to read it. You would use a service like Prometheus? Answer, yes. Mr. Nye, no further questions. The court, thank you. Now the court asks, line 22, redirect. Ms. Taylor states, no, Your Honor, thank you. The court, thank you, doctor. You can step down. This is the bottom of page 164. And then at the top of page 165, is that the state's last witness on this issue? Ms. Taylor, the defense. Yes, Your Honor. So here the court was thinking that this was the state's witness, last witness, when actually all of these witnesses that we have heard from and that we see in the transcript are defense witnesses. The defense called all 5 of these witnesses. So that it continues. Ms. Taylor, defense. Yes, Your Honor. The court, pardon me, defense. I'm used to the state going first on things. I apologize. Does the state have witnesses? Mr. Nye, Your Honor, no. We're not going to call Dr. Middleman. So it appears that there was a potential another witness here, a Dr. Middleman, who the state has decided we're not going to call him. Line 9, the court, I'm trying to recall what I said about argument on this issue, whether I said we could do this publicly or not. I want the parties' input on that as we make that decision, whether we can argue the Franks and the suppression issue on IGG publicly. I know your position is we should, but in light of my ruling, can you? Ms. Taylor then responds, line 16, Your Honor, I'm going to refer to what the feds did in here. I'm going to refer to the Department of Justice interim policy. I can probably not name the 4 brothers that the state lab tested. The court, okay, can we avoid talking about the fact of the 4 brothers? Understanding. I understand that's there, but I'm not gathering the import of it or the issues at hand. I think you could reference that there was some information that itself was insufficient to generate a profile, and I know, bottom of page 165, what you're talking about. Ms. Taylor then responds, I'm trying to think of how I could do it. I want to make sure I've made a really good record here. The record is very important. The court, of course. So what is she saying here, making a record? This is in the event that this motion gets denied, which we know that the motion to suppress IGG, as well as all of the other 13 suppression motions, were denied. So she's saying, I need to make a record here in the event of an appeal. Ms. Taylor, I'm trying to think of how I could do it. I want to make sure I'm making a really good record here. The record is very important. The court, of course. Ms. Taylor, I think I can talk about Othrum's recommendations that were attempted to be followed, but nothing worked. I think I can do that. Maybe, after hearing the evidence, if there is a ground for the court really wants me to stay away from, other than saying the 4 brothers, maybe that would be helpful to know. I'll try my best, Your Honor, but I really want to make a really good record for Mr. Kohberger. The court, counsel, Mr. Nye, Your Honor, I think we can probably do the argument publicly. I don't need to reference the brothers. I don't need to reference any of the specific names. As I explained earlier, and as the court has seen, we didn't put on evidence one way or the other as to whether the policy was followed, for example, so that part of the argument is even assuming from our perspective, I think we can probably do the argument publicly. The court, I thought I made it clear what the bottom page 166 to 167 I've tried to do is open up evidence, whether for the state or against the state in this case, that potentially is not coming into trial, that could influence potential jurors. I didn't hear a lot of that today. I think the first that there was investigative genealogy done in this case is not necessarily a secret, given that we publicly talked about that. We're going to talk about that. I think the more specific things about what happened within that, it's best if we kind of refer more generally in terms of like the 4 brothers and whatnot. I think, frankly, it's appropriate to discuss how law enforcement handled the profiles that they received. I think it's appropriate to talk about whether or not these profiles, whether privacy is at issue in these profiles. I think that obviously the state is going to talk about standing and other issues in your client's specific privacy rights with respect to this, as I think that's appropriate. So I think we're generally okay, staying away from some of the specifics that I'm not sure what ultimately could be admissible at trial. Even if I were to say, well, admissible at trial, the whole IGG issue, I'm not sure that's going to be admissible at trial. I suspect the search, the trash pull, is going to be admissible at trial, but that's genealogical match, allegedly to Mr. Kohberger's father, as I understand it, and the lack of attempt to figure out, I think what I'm understanding, at least from the testimony, the attempt to figure out the mixed profile. So I think it's all fine. The preference is staying away from the specifics as to what those genealogy searches showed, more specifically that we talked about the brothers and the names of the individuals who were testified to, if that makes sense. Ms. Taylor, it does. We have an affidavit attached to the back, I think, of our reply briefing on the suppression issue. I want to make sure the court looks at that. That's admissible as evidence, and I probably don't want to refer to that publicly. Would you like my copy? The court, what was the date of the filing? Ms. Taylor, it should have been the 19th, December 19th. The court, what was the name of the document? Reply to, objection to. Ms. Taylor, this was the reply to the state's objection to the motion to suppress IGG material, bottom of page 168 into 169. It's not showing on the 19th. Oh, here we go. It was on the 20th. What is it you want to reference in the argument with respect to this affidavit? Ms. Taylor, standing, Your Honor, I don't need to reference that particularity. I just wanted to draw the court's attention to it. The court, in particular, the standing that the affidavit suggests that the unknown E was Mr. Kohberger. Is that what I'm reading? Ms. Taylor, no. That there was a sample within the trash that was Mr. Kohberger's. The court, okay, I'm not sure the state's arguing that there's no standing as to the trash. I think the standing argument related to the genetic testing through the companies and to the objection to the testing of materials found at the crime scene. Am I correct about that? Mr. Nye, Your Honor, we did assert in our briefing standing. It was kind of in passing in the sense that we think the fact that it was a trash pull resolves that issue. The court, I appreciate the trash pull legal issues in terms of privacy standing, but in terms of standing of, quote, this is not Mr. Kohberger's DNA, so why am I, 169 going into 170, hearing from him, end of quote, standing, which is part of what you argued in the IGG information. Mr. Nye, correct. The court, there's that issue. I don't see that impacted here because it sounds like some of his DNA was in that trash. And then there's the standing issue, as I understand it, related to the extent that the defense is not conceding that the DNA found on the knife sheath was Mr. Kohberger's. He has no position to object to the testing of DNA on the knife sheath. Mr. Nye, correct. The court, I don't see there, frankly, that this is an argument as to the standing issue of, quote, not his DNA, end quote, as it relates to the trash pull. That's just how I see it. If you think that's different and you need to make that argument, you need to let me know so that I know what we're getting into. Mr. Nye, no, Your Honor, it's not different than that. What happened is the opening brief. They asserted there was DNA found in trash, including in identified male. And the response, I said, well, that's not standing. You can't just say unidentified male. In the reply, they attached this saying, well, we looked at it and it was his. That's sufficient. Don't plan on arguing that point. End of 170 going into 171. The court, all right. Are we all square then, Ms. Taylor? I think so. The court, if you have a question of doubt, ask to approach and we can go offline real quick. I would rather err on the side of being cautious than not. Ms. Taylor, may I have 5 minutes? The court, no. We're going to take more than that because I need the public to be notified. So we're going to take at least 15 to 20 minutes. Mr. Nye, Your Honor, can I just briefly ask? We have some of the victims in the hallway. I guess they've been told by somebody they can come in when the hearing was open. The court, I'm not sure who would have told them that. Mr. Nye, I don't know either. That's just what they're representing to us. We didn't understand that to be the courts. The problem is I don't want to have to chase them out. Mr. Nye, absolutely, understood completely. The court, Sandra can have a TV in the conference room that they can watch it on. That's fine. Mr. Nye, okay, thank you, Your Honor. The court. And then my understanding is we can then go into the next evidentiary phase without a problem, and it can be public, correct? Mr. Nye, yes, from our perspective, Your Honor. Ms. Taylor, Your Honor, I think our team might be a little bit confused about that. I think we thought that Franks might be next, but the court, no, after the Franks. Ms. Taylor, okay. So I'll do suppression, IGG, and then the court will do the argument on that, unless you want to go straight into the evidence and come back to the argument on the Franks, IGG. Ms. Taylor, okay. The court, and do it together with the suppression stuff. Ms. Taylor, no, I plan to do that when I did all of the Franks, to introduce the entire Franks. I think I'm confused about when the court wanted me to do that. If you want to take more evidence today, if we are open to argue IGG and be done, and then if the court wants to finish with evidence today, and then we will do a Franks tomorrow argument, the proper argument, the court. So my preference is, because I don't want to get into an evidentiary phrase of Franks, bottom of page 172, ladies and gentlemen, going into 173, other than the issue of IGG, is to argue your Franks motion next, including the IGG and your proffer for the other Franks issue, and then we can go into evidence on the suppression issues. Does that make sense? Ms. Taylor, that does make sense, and that's perfectly fine. I might need a minute or two to pull that box out after we're done with this argument, if that's okay. The court, sure. You can always have a minute when you need it. Mr. Nye, Your Honor, I'm sorry to complicate things, but just to be clear, so over here we've split that Ms. Jennings is handling the Franks and I'm handling the direct IGG suppression. Is that okay if we split it that way? The court, sure. Mr. Nye, thank you. The court, again, my thought was we do all the Franks, including the IGG stuff next, because I don't want to take evidence that is then going to be said is part Frank's, because if the state's then asserting it, I think I've cracked the egg on whether or not I can decide the issue prior to a Frank's hearing. So that's why I want to have it wrapped up before I take more evidence. Okay, Mr. Nye, sounds good. The court, all right, will take about 20 minutes or so to let the public have notice. End of closed proceedings. And this is at the top of page 175. And then if you go to 176, this is the court reporter's certificate. And it tells you that she is who she is, certified court reporter. And she states that the foregoing pages comprise a full, true, and correct record of the proceedings in the above entitled cause. That said proceedings were taken by me, stenographically, and then thereafter reduced to typewriting under my supervision, that I am neither counsel for or related to, nor employed by any of the parties in this case, and have no interest, financial or otherwise, in its outcome. In witness thereof, I have unto here set my hand this 4th day of February 2025, and we have her name, Christy Valid. So it looks as though she completed this transcript on the 4th of February of 2025 and then signed her signature. She has to certify that she's got no stake in the action, and that's what she's done. If you would like to take a look at this transcript, again, please follow the link that I have provided in the description to this podcast episode. There's some very important information here. I think it takes a few reads in order to digest everything that's stated here that we, the public, are learning about for the first time. I think that testimony from Dr. Larkin was very interesting about some of the discovery that went back and forth, about some of the databases that she believes and the defense believes that there's evidence that were entered into that should not have been. There is also just so much information here in this transcript. Please do take a moment and read it, because it is the first time that the public has really been privy to this amount of information that has been under seal for so long in this case. My name is Kathy. This will now conclude this episode of the Indie Zone and also this special series where we have evaluated and discussed the transcript from the closed hearing of January 23rd, 2025, presided by the Honorable Stephen J. Hippler, District Judge, who is presiding over this case. Thank you for joining us here today.